Sahaj Vidhi www.sahajvidhi.in. Question 1. Nuisance is branch of negligence. Explain, describe who can sue and who is liable for nuisance. Model answer. The statement a nuisance is no branch of negligence highlights a fundamental distinction between these two torts. While both can lead to civil liability, their underlying principles and elements differ significantly. Nuisance versus negligence. Focus. Negligence focuses on the conduct of the defendant specifically, whether they failed to exercise reasonable care, resulting in harm. Nuisance, on the other hand, focuses on the result of the defendant's activity and unreasonable interference with the plaintiff's use or enjoyment of land. Private nuisance, or a public right. Public nuisance. Duty of care. In negligence, a duty of care must be owed by the defendant to the plaintiff. In nuisance, the duty is generally to not cause an unreasonable interference with another's rights, irrespective of a specific pre-existing duty of care. In the negligent sense, fault to care, a defendant can be liable for nuisance even if they have taken all reasonable care to prevent the interference. For instance, a factory owner might install the best noise-reducing equipment, but if the remaining noise still constitutes an unreasonable interference with a neighbor's enjoyment of their home, it could still be a nuisance. In negligence, the absence of reasonable care is the very essence of the tort. Liability element. Nuisance often carries an element of strict liability, especially in cases of private nuisance, where the focus is on the harm caused rather than the fault of the defendant. If the interference is unreasonable and causes damage, liability arises even without proof of negligence. Who can sue for nuisance? 1. Private nuisance equals this involves an unlawful interference with a person's use or enjoyment of land, or some right over or in connection with it. To sue for private nuisance, the plaintiff must have an interest in the land affected. This typically includes owners of the land, tenants or leaseholders. Occupiers with exclusive possession, e.g., a licensee with a proprietary interest. A mere licensee or guest generally cannot sue, as lack a proprietary interest. 2. Public nuisance. This is an act or omission that causes annoyance, inconvenience, or damage to the in general, or to a section of the public generally. A nuisance is a crime and is prosecuted by the state, e.g., under Section 268 of the IPC. However, a private individual can sue for nuisance in tort if they can prove that they have suffered special damage over and above that suffered by the general public. This no quiet may second a public. Special damage must be direct, substantial, and not merely a matter of degree. Who is liable for nuisance? 1. The creator of the nuisance. The person who directly causes the nuisance is always liable, regardless of whether are the owner or occupier of the land from which the nuisance emanates. 2. The occupier of the land. The occupier, e.g., owner, tenant, of the premises from which the nuisance originates is generally liable, even if they did not create it, if they adopted the nuisance, used the source of the nuisance for their own purposes, continued the nuisance, knew or ought to have known of the nuisance and failed to take reasonable steps to abate it, authorized the nuisance, permitted another person to create a nuisance on their land. 3. The landlord. A landlord is generally not liable for nuisances created by their tenants. However, they can be held suable in specific circumstances if the landlord authorized the nuisance, e.g., leased the premises for a purpose that inherently involves nuisance. If the nuisance existed at the time of letting and the landlord knew or ought to have known about it. If the landlord covenanted to repair the premises and failed to do so, leading to the nuisance. If the landlord retained control over the part of the premises causing the nuisance. In summary, nuisance is a distinct tort focused on the unreasonable interference with rights, independent of the defendant's carefulness, and liability can extend to creators, occupiers, and sometimes landlords, with specific rules governing who can seek redress. Please visit our website www.sahajvidhi.in for more content.